Good afternoon, everyone, and welcome to the 5th episode of Divorce Law Monitor's webinar. We are so glad that you could join us today. My name is Francine Gardikas, and I'm a partner at Burns & Levinson, and I'm joined here by my partner, Andrea Dunbar,
Hello,
as well as Gregg Cohen of Campus Bound.
Good morning.
Today, we're going to talk about college planning for your teenage children while contemplating a divorce, while going through a divorce, or being in a post-divorce status. Before we begin, I thought it'd be helpful to get to know us a little bit better. Gregg, if you could give us a little bit of your information, and then we'll go to Andrea, and then I will fill in my information afterwards.
Thanks, and thanks for having me today. So my name is Gregg Cohen. I'm the president of a company called Campus Bound, and we're located in Eastern Massachusetts. We've got 4 offices, and we are a full-service college consulting company with helping students through the college admissions process, college search, applications, as well as the financial component in terms of helping families to figure out how much they can afford for college, how to stretch that, and get as much financial aid as possible and reduce the cost in as many ways as you can. So we've been doing this for about 20 years. I've been involved with this, and I spend a lot of my time on the financial side of things and trying to help people to navigate this process that's become completely expensive and completely difficult to navigate in terms of getting the discounts that you can take advantage of. We have a team of 40 counselors, primarily former college admissions officers, high school, private school counselors, as well as financial aid officers from colleges. So a very experienced team that live and breathe every day of helping students to get through this and helping parents to find a way to make it all work. And in doing so during this time, we've worked with thousands of families in a very hands-on way in all aspects of this, sending a child to college.
Andrea, why don't you tell us about yourself?
Thank you. As Francine said, I'm a partner here in the private client group at Burns & Levinson. I practice in Massachusetts and Rhode Island. I've been practicing for approximately 12 years. I focus my practice in all areas of domestic relations in Massachusetts and Rhode Island, including divorce, alimony, child custody, paternity, and issues affecting non-married individuals. I also do probate litigation and some estate planning, which is helpful, especially when I'm dealing with domestic relations cases that involve complicated assets such as trusts. I've been with Burns & Levinson for 10 years. I started my career as a law clerk for the Massachusetts Probate and Family Court. In my position as a law clerk, I assisted judges with writing decisions after trials, and this was eye-opening as it made me realize that oftentimes you don't want the man or the woman in the black robe making decisions for your family. So I'm happy to be here today, and I thank you for joining us, and I'll turn it back over to Francine.
Thank you, Andrea. I have been here at Burns & Levinson for over 16 years and have been practicing divorce law for over 20 years. Like Andrea, I too focus my practice on all aspects of domestic relations, which includes divorce, alimony, child support, child custody, paternity, and also, like Andrea, I started my career as a law clerk with the Probate and Family Court, and I worked there for 2 years. I also had the opportunity to work for Whiting for Aronson and Monroe Inker, who at the time was locally known as the attorney who wrote the book on divorce law in the 1970s and 1980s. Again, thank you for joining us. And to get started today, Andrea is going to talk about how you can start considering the divorce process and where you are in your divorce process and how that applies to your thoughts on college costs and admissions.
Thank you, Francine. So as Francine said, in determining what plans you're making for your teens' college education, and if divorce is an issue, you really need to consider what stage of divorce am I in, and how is this going to impact my teens' college plans? And so the way that I look at it is there are basically 3 stages of divorce that you can be in. You can be contemplating a divorce, you can be actually going through a divorce, or you can be post-divorce. And when I say contemplating a divorce, I mean that there's no divorce on file nothing's been filed with the court, and divorce is just something that is being considered. And so when you're in this stage of divorce and you're contemplating divorce, the first question is do I file for divorce or do I not file for divorce, and how does that impact my teen in college? I think if you're in a particular space where your teen is on the cusp of going to college and you and your spouse have worked out what school your child is going to go to, how the payment arrangements are going to be made, it may not make sense at that point to file for divorce because it could throw a wrench into what everyone is expecting. On the flip side, it may be a situation where your teen is ready to go off to college and just your spouse is being uncooperative and plans cannot be made for your teen. So perhaps if that is your situation and you've been contemplating divorce, perhaps in that situation you need to actually file for divorce so that you can work with your attorney or the court to get some orders that allow for some certainty for your teen and the college process. The other thing you want to think about is if I'm contemplating divorce and I file for divorce, how does that shake up financial arrangements and access to funds in order to pay for college? And you also want to think about, if I file for divorce, how does that affect living arrangements and throw a wrinkle into my teen actually being comfortable and settled for purposes of starting their college career. The next stage of divorce is actually going through a divorce. And the way that I define this is that there's a divorce on file and you are in the midst of a litigious process, either via the courts or negotiations with your attorney. I think if you are in this stage of divorce, you need to consider who is going to pay for expenses, including college preparatory expenses. And you may need to, depending on how your teen's college career intersects with where you are in the divorce process, you may need to seek what's called a temporary order from the court regarding your teen's college needs in the event that your spouse is not cooperating. The other thing you want to consider here, again, when you're actually in the midst of a divorce, is putting in your separation agreement exactly what is going to happen relative to your teen's college career. And so some of the things that you want to think about is, how are decisions going to be made between my spouse and myself as it relates to institutions to be attended? You want to think about who's going to be responsible for what costs, whether that's college preparatory costs, whether that's tuition, room and board, etc. You're also going to want to think about what is a college cost. You want to define that, and then you want a very specific definition. And you also want to think about financial aid. How is financial aid going to be allocated? I had a case where we were discussing college and we were talking about loans, and the parties actually agreed that if there were any loans associated with college costs, that the husband would be responsible for the loans. So it's something to think about as you are preparing a separation agreement, and you want to be very specific because you want to ensure that everyone knows what their obligations are, and at the end of the day, everyone's getting the benefit of the bargain, and ultimately the person that is not losing out is your teen. Couple of other things you want to think about with respect to your separation agreement. You want to think about any property that is held for the benefit of the child and how that's going to be applied to college costs. So for instance, UTMA accounts, 529s. The other thing you want to think about is post-divorce college savings. So how is that going to be applied? And that should be addressed in your separation agreement, because you don't want to get into a situation where one parent thinks, well, I've saved $100,000 post-divorce for my child's college education. And, the other parent thinks, well, I haven't saved anything. So of course, my spouse's 100K is gonna come in real handy. So you really want to be clear about what the obligations and what the responsibilities are. The last stage of divorce is post-divorce. And so if your teen is getting ready for college and you're post-divorce, the first thing you're going to want to look at is, what does my separation agreement or my judgment say about college responsibilities? And oftentimes, if you get divorced when your children are very young, it may be a situation where your separation agreement or your judgment are not at all clear about what the responsibilities are. And hopefully, if you're in that situation and you and your spouse can't agree, there is a mechanism via your separation agreement for you to file what's called a modification to make more clear what the obligations and responsibilities are as it relates to payment of college. So I just went over a lot of information, and we're going to dig deeper into a lot of these topics throughout our presentation. So I'm going to turn it over to Gregg, who's going to talk about navigating the college admissions process.
Thanks, Andrea. I think that there is a lot here, and I think good points in doing that. I want to just take a little time just to give people some context in terms of the timing. The college admissions process, it really starts throughout the high school career, especially as you get to the second half of the high school. But the 9th and 10th grade is a great time to do well in school. That's going to be the most important factor in the financial aid and also the admissions process. And maybe towards the end of the sophomore year, starting to peak at schools. The junior year is when you really are going into finding schools that are good matches. And that's why it's absolutely critical to set some of those ground rules that Andrea was talking about in terms of budget and things like that. So what are the criteria that you all have, and find those schools, and also do some testing and SATs and ACTs and other steps that you'll need to do during the junior year. Because by the time you get to the summer before your senior year, that's when you're going to really be going into the application process, writing college essays, doing supplemental essays, asking for recommendations, doing more testing. So this process moves pretty fast. It's actually by the middle to end of November when those early applications can be due. And for regular decisions, January 1st. So careful planning and careful upfront discussions is really important as you go through that. One of the things that I put a lot of emphasis on is what really is critical factors in doing this. So maybe you could change the slide there. These are some of the things that I point to, and just sort of words of wisdom, having done this for 20 years, especially in a divorce, when there's been a divorce or in a divorce ongoing, that I think people should do. And that is starting early and make sure that you determine and communicate expectations all up front. I've seen so many times where one parent is not as involved until the very end, has their own set of expectations or goals or what they're willing to spend on college. So really make those plans about what's your budget, who's going to be responsible for what. If there are restrictions about where the student's looking, maybe because of geography, or maybe because a parent has some biases or preferences about a region or a type of school, make sure that's all up front so it's not somebody coming at the last minute. And same thing with the application process. I've seen over the years where a parent wants to, that hasn't been involved with the process, wants to change the student's essay at the last minute. And that's very frustrating for all involved. So really set up the ground rules early on as you go through this, and set interim deadlines along the way. Because if one parent's not as hands-on as the other one, they're going to feel lost. And so there's an emotional part for each parent, even though they're coming from different angles and different perspectives on the whole process. And among everything is keep it student-centered. It's so hard when parents have their histories and maybe they've been fighting a lot. They continue to fight through the divorce over the course of years of being divorced. Make sure it's the student's goals in mind and you're there to support them in this venture to the best degree that you possibly can, both through the search and application process as well as financially. Now, I mean, this is where a third party can really help, because it's just an independent set of eyes on these things, because it is emotionally driven, and there's a lot of money at stake. Next, you were talking about college costs, and when I talk about college costs, what goes into a college cost, right? Francine, you want to take that back?
Yep, thank you so much. One thing I wanted to mention is that oftentimes, Greg, when children are applying to college, they are not yet 18 years old. And so in the divorce world, we need to be mindful of the fact that a 17-year-old is still under the jurisdiction, if you will, of mom and dad, or mom and dad, such that the child can't really make legal decisions on his own or her own. Versus when a child is 18 years old, they have graduated to being a true adult, and they are the ones who have the legal authority to make decisions. But of course, they don't have the ability to pay for all of their college decisions. And so that brings us to, what is a college cost? College costs are all encompassing. They start from what Greg said, the search, right? So the search comes in junior year, where you're traveling to schools. Well, maybe not in the time of COVID, but there was traveling to schools and flying out to different regions of the country to, find your best place. So costs start at that stage in terms of the search. Also, costs start when a child is preparing for his or her SATs or ACTs, those prep classes, as well as taking those entrance exams. And so what's really important here is to define college education expenses. Our courts have determined that college education expenses shall include tuition, which is defined by the University of Massachusetts tuition at that particular year, reasonable food and housing costs, and if a child is going to be off campus, then off-campus costs cannot exceed on-campus room and board charges. And this is important, especially in COVID times, when a lot of students are not interested in being in a huge dormitory, or the dorms aren't really available. And so a lot of the upperclassmen are seeking, off-campus housing. College education expenses also includes laboratory fees, registration fees, books and supplies, student activity fees, all the items that you would normally find on a college bill. You also need to consider reasonable allowances for transportation to and from the college, and for the child to be able to return to both parties' homes if that's part of the parenting plan. It's just vitally important to have a clear definition of what's included. And I caution you for just not saying all expenses. It's best to give a list, if you will, as I just mentioned. Also, there's a good opportunity at this time to have clear expectations as to what that all means. For example, if you give your daughter, money for beer and pizza on a Friday afternoon, $50, does that now mean that your spouse or your ex-spouse has a responsibility, for half of that cost? As I mentioned earlier, there's room and board versus living off campus. Not only do you need to, figure out the cost of both of those, but who's going to be responsible for signing the lease of off campus? Again, it's unlikely that a landlord is going to just allow a bunch of 18, 19, and 20-year-olds to sign a lease without a parent or parents signing on. Also, you need to consider what reasonable costs are with regards to supplies. Years ago, when I went to college, no one had their own computers. Gosh, I'm really dating myself, but we would bring word processing systems to school. Now everyone has their own computer, printer, Wi-Fi access, iPads, and all those electronics. You need to consider those costs. And so understanding and having a good grasp of how much all of this is going to cost comes into play when determining contribution and whether or not child support continues. And I know at this time, Gregg is going to provide us with some more details as to what college costs in 2020.
Yeah, but the question is what really goes into it, and there's some real variation there. And I think that as you're planning as a parent, you can really think about what level you're able to and willing to support. As you can see on this graph here, you've got highly selective colleges that are private colleges that are, $75,000 a year. There's a school out there now, University of Chicago, that just hit $80,000 per year if you're paying the full fare. Moderately selective private school or a out-of-state public university, if you're in Massachusetts, maybe that's University of Rhode Island or University of Maryland, those are roughly $50,000 a year, and they're increasing, 3, 4, 5% a year. It seems even these times, many schools are still increasing. And then even to go to an in-state institution in Massachusetts here, UMass Amherst is in the low 30s, Westfield State or one of the other state schools, if you're living on campus, and this is the full price. This is if you're living, eating on campus, the fees, it's $25,000 to $1,000 or higher. So they're quite expensive and quite varied. But one of the things I'm going to talk about this part is that there's a lot of tuition discounts. It's actually a relatively small number of the population, maybe depending on the school, it could be 20, 25%, or even less that pay that full fare. So you have to understand what kind of discounts you might get as you make your plan. And then if you're borrowing, you also have to think about the cost of the loan. So, as you're factoring all of this kind of thing in, or for you or your student, you want to, consider those real costs on that. And then depending on how you pay, there might be taxes. There might be an impact on your retirement if you're taking money from a certain account or not aggressively contributing to that account as much. So a lot of factors go into it. So the published prices can vary, but it's not necessarily the whole true cost of what you're paying. I think taking the time up front, understanding, are you eligible for financial aid? What is really my cost going to be? All those items that Francine listed is really vital to getting your handle on it because it is such a big investment. So maybe I'll transition now into some of the ways that you can get tuition discounts. There's a lot of free money out there, a lot of money that just comes off the tab, and it's how you get it and also how that plays into when you're divorced or you're even separated. So let me give it some context first, though, with some of how the financial aid system works. There's two kinds of financial aid. There's need-based aid and there's merit scholarships. And I'm going to throw up a couple of examples here about need-based aid. And you can see how different schools of different price levels can really vary in what the real cost is going to be. So with this example here, I said this one school costs $60,000 and the second school is UMass Amherst. That's around 33 when you talk about all those costs. The financial aid system is going to come up with a number called your expected family contribution or estimated family contribution, which is a way that they figure out how much you're able to pay. It's not really realistic for many families, but that number that they use as a baseline is then subtracted from the cost, and that's your eligibility for financial aid. So the eligibility for financial aid at the expensive school is quite a bit more than at the state school. Schools will also, so then they package you. So the school on the right, on the college number one, meets 90% of the need with a combination of loans from the government, maybe a work study, which doesn't get discounted off the tuition, and then grants or scholarships, which is free money. And they might not meet all of the need. They might not get all the way down to that 25,000 number, but they might do a substantial amount. So in this example, the school costs really for that family $36,000 because they got $24,000 off of the 60. And the other example, though, the whole need was that they were going to meet was in the form of loans. So the real cost there was the $33,000. So even though these schools have a price tag of $27,000 difference, based on this family's financial situation, there's only a $3,000 difference per year in the real cost. And I think it's critical to understand where you stand because it might affect what schools make the list. Because that school might get, like I said, that expensive school you might rule out, maybe it goes down to a lower amount. Now, if this formula is particularly friendly to you, there's still a lot of opportunities with merit scholarships. So schools can discount the tuition based on how they see the student, in terms of their academic profile or their other parts of their application. So there's ways to discount the tuition. There are some schools that, less than 10% of the people pay the full fare. They mark it up to get that 10% that can pay it and are willing to pay it, but they know that there's going to be a lot that aren't going to pay it. So you want to really evaluate what your potential is. So what goes into that? What are the key factors? Well, one of the key factors, if you go to the next slide, there's some, and how this also plays into divorce, is parents' income is the biggest factor. And that is the year before they go. So if they're going to school in fall 2021, it's the 2019 income year that's counting. Students' income matters, and that is if they've got a job at the local grocery store. Some parents' assets matter, but usually to a lower degree. Student assets like UTMR accounts or trusts, and the number of kids in college matters. So you might be eligible differently when you have multiple children in college. Now, where this gets really interesting is if there's been a divorce or separation. And you don't have to be formally divorced to have these criteria come into play. The parents can just be separated. At many schools, all but about 200, they just consider the custodial parent, and if they're remarried, the step-parent's finances. And to be considered a custodial parent, it's whoever the student lives with 50% or more the prior 12 months. So it's nothing to do with the divorce agreement you made when the child was 4. It's got nothing to do with who's providing more financial support necessarily. It's who they live with most recently. Sometimes when it's like a 50-50 situation, there might be some play there about which parent is reporting on the financial aid forms. Now, there are many schools, 150 to 200 private colleges, typically more selective private colleges, that will look for the information from the non-custodial parent as well. If the non-custodial parent is willing to complete the form, not in the picture, there can be a waiver granted. So if there are exceptional circumstances as a result of the divorce, then you can go and communicate that to the colleges directly. If you are submitting financial information, that information remains confidential at the colleges. So sometimes parents are in a contentious divorce, might be unwilling because they don't want to share their more recent financial information. It will remain confidential, and it doesn't necessarily obligate them to pay for college. So some people worry, well, they're going to see my finances and they're going to expect me to be the one that pays, even though my divorce agreement might say something completely different. That is not something you need to worry about. It's completely separate. They just want to get a feel for the overall family's ability to pay. And it might reduce your eligibility for financial aid, but it won't necessarily obligate you to pay. So I think that these are things that, as you're thinking about the timing of where a student might live, who's filling out the financial aid form, it really could matter. And looking at the schools that maybe look at one parent versus looking at both parents, because that might affect your eligibility for financial aid. Okay. Move on to the next step here.
So before,
that was all I got.
Sorry about that, Greg. I stepped on your toes.
No, I was all set. I'm going to flip back to you.
Thank you. So as Greg mentioned, you have to figure out how to pay for college. In Massachusetts, during a divorce process or at the end of your divorce, you know that Massachusetts child support guidelines apply typically, and there's an establishment of a child support order. So when a child reaches 18, there are typically opportunities to modify a child support order, and that's something that I know that Andrea mentioned at the beginning of this. So if parties are already have an established child support amount and college was far off in the divorce process years ago, there's an opportunity to modify. At that point, you need to ask the court to modify the child support amount and also weigh in on whether or not there'll be contribution to college. A court, a judge, has the discretion to either order contribution to college or decline college contribution. When a court orders a contribution to college, the judge will consider the cost of the college, the child's abilities and aptitudes, the child's living situation, if the child is going to be staying at home or living in the dorm room. Of course, resources, financial resources and income of both parents, and the child, and whether or not that child has, had a summer job or has had any type of personal contributions and commitment to his or her college experience. And of course, most importantly, availability of financial aid, and how that's been broken down, whether there's been loans, grants, scholarships, or again, any type of work-study program. Our courts at this time cannot order a parent to pay more than 50% of UMass Amherst unless there are specific findings that a party has the ability to pay more. Those findings are only done after a divorce hearing or a modification hearing where true evidence has been provided, and some type of evidentiary hearing. The court also has a discretion to order child support and completely modified order college contribution and modified child support such that child support is minimal. Sometimes judges have done the following, where they've taken the current child support order, and instead of paying on a weekly or a monthly basis, a judge will consider how much time a child is actually home residing with a parent and only have the parent paying child support pay for those weeks that the child is home. So for example, winter break, which is about 3 to 4 weeks, or summer break, which is typically 10 to 12 weeks. So you would have the parent who has an obligation to pay child support to pay for about 15 or 16 weeks of the year as opposed to all 52 weeks. If a court does do that, then the judge takes into consideration that, lesser amount of child support and then looks to see what that parent can contribute and whether or not it should be more than the UMass standard. If ordering child support for a child over 18, the court must consider the reason for the child's continued residence with or dependence upon a parent for child support. And then the court should also look at the child's academic circumstances. Not all children launch at graduation from high school. They take gap years, which, especially in the time of COVID, there's been a lot of talk about gap years and trying to find where the child truly belongs, and as opposed to not experiencing the full college experience. And of course, there's costs with gap years, and your separation agreement may not even address gap years. There's always the hope that a child will go to college in 4 years and done, as opposed to any type of longer program, which of course adds to cost. So the court may not, may consider that a gap year isn't part of a college experience, and that if the parties and the child decide for the child to attend the gap year, you need to find the financing on your own. So the court also, there's interplay, I guess it's most important to know, is interplay between child support ordered, the amount of contribution, and the amount of financial aid available, and how that's going to be considered, and who would be most responsible for paying the differential, right? So if you have a child who's going to a $75,000 a year college, it's unlikely all of that's going to be paid by financial aid, grants, and scholarships. So then you need to figure out how are those scholarships and grants going to be allocated, and who's most responsible. Will your child have a responsibility to contribute? A lot of judges have said, that this should be a 1/3, 1/3, 1/3 split, which means you take the cost of UMass at $33,000, and mom is responsible for 1/3, the other parent's responsible for 1/3, and the child's responsible for 1/3. That all needs to be taken into consideration. And so, Greg, can you tell us a little bit about paying for college options and those considerations, including loans, and who's responsible for applying for those loans and paying for those loans?
Yeah, no, and you make a really good point about how that financial aid that's applied, who's going to get credit for that, right? And how realistic is that? And it goes back to really come up with these agreements, hopefully, mutually agreeable and easily agreeable, but it's really important to have that settled going in. Because if the student gets financial aid, is that going to get the credit from the mother's account or the father's account because they were the one that were eligible for financial aid? Was it discounted off of the student's requirements? So I think it's all important to do that, because there are a multitude of different ways that you can pay for college, and you don't have to do the same way as your ex-spouse, or the student. one parent can decide to pay directly to the school. One parent can take a loan and have that applied to the school. Students can take a separate loan and have that applied. So there's a lot of different ways that can be done. The fact the bill comes to the student, you talked about at the beginning how the students are 18 and now all of a sudden they're getting the bill. They have to grant you permission as a parent to see the bill. Then separate accounts can be sent in different ways. But if a student's going to borrow beyond those government loans, somebody's going to need to co-sign that loan. So who's going to be the co-signer of that loan? And I've seen, some pretty strong arguments among, parents in a divorce about who's going to be responsible for that, because that parent, if the student defaults, is going to be responsible for it. And if there is they're co-signing, so it affects their credit. So, there's a lot of things, and even the rate that a student might be able to get on a private loan will be dependent on the credit history of the co-signer. So this matters. This definitely want to think through these things about who's going to be responsible for any student loan support. But there's a lot of different plans out there, different rates. But I think it's important to measure that up very carefully because it's, it could matter in terms of how much you ultimately pay.
Greg, I have a question. Can a student obtain enough loans to pay for these private colleges without a parent's involvement? Or is it almost impossible to do so without a parent signing on?
Yeah, you really need a co-signer. It doesn't have to be a parent. It could be a grandparent, an uncle, or whomever. But if there are exceptions where I have seen students that are of normal college age getting private loans, but the rates would be very high if you're able to qualify because they're a very risky,
right,
loan. So generally speaking, somebody's got to co-sign the loan.
And what if you have a parent who just absolutely refuses to participate and help?
Yeah, I mean, as I said before, if the parent, ex-spouse refuses to fill out the financial aid form, you can get a waiver from the colleges. If they are refusing to pay it all, then, you can try to communicate that to the colleges because maybe it helps their financial aid package. But really, ultimately, that's something that you have to wrestle with, whether you choose a school when you're only getting support from the one parent. It's how you pay for college is somewhat your problem. You can try to negotiate and try to get to understand that there's only one contributing parent, but ultimately they're going to give the award they want to give you, and you've got to figure out how you're going to do it.
Right. So Andrea, maybe you can talk about how we can force a parent to do it and with their refusal. And I think there are a couple of questions from our audience that we can answer as well.
If you're in a situation where the other parent refuses to pay for college, it's really your ability to force them to do so is really going to be dependent upon what your divorce agreement says and or your judgment if you went to trial and you did not enter into a divorce agreement. And that's why we've emphasized at the beginning of this that it's really, really important for that separation agreement, that contract that you enter into with your spouse, to be very clear. And because in order to file what is called a contempt, that's your remedy if your spouse refuses to pay for college. In order to file a contempt, you have to show that there's a clear and unequivocal violation of a clear and unequivocal order. So let me break that down a little bit. What you have to show the judge is that your contract, your separation agreement, requires your spouse to pay this money, or your ex-spouse, and your ex-spouse has refused to pay the money. So if the language is wishy-washy or isn't totally clear, then you're not going to have a remedy. You're not going to have a contempt remedy to force your ex-spouse to make those payments. And so what ultimately happens is that the spouse that is advocating for the child, is advocating for the payment, is really left in a really tough spot, because you're looking at, okay, do I have the money to pay up front? and then chase my spouse for it? And if I can't get the court to order my spouse to pay it, do I have the financial means to pay for it all myself? Because I certainly don't want to disappoint my teenager. And again, this all goes back to making sure that obligations are clear and ultimately, everyone knows what they're responsible for. And just to reiterate a couple of things that Gregg said, you may want to reach out to the college and certainly being mindful of privacy, but you want to explain to them why there's payment issues before it gets to the point where the college is kind of looking at, do we need to ask this this child not to return, or we need to explore options for not allowing them to attend class or something like that. The other remedy that you could potentially have, depending on, again, your separation agreement and your judgment, is that if your agreement is not clear about who is required to pay for what, you may have the ability to modify that agreement to make it more clear. But again, that depends on your separation agreement and what it provides for. So that would be a contempt and a modification are the potential remedies for forcing your spouse to pay for college in the event that they refuse to do so.
So it looks like we have two questions from some participants. And the first question is, does Massachusetts State College tuition, is it a cap? And do the Massachusetts courts assume that parents and the student split responsibility as 1/3, 1/3, 1/3? So I think we've kind of answered that, but the answer is yes, the judge could consider 1/3, 1/3, 1/3, but the judge doesn't have the authority to order a child to contribute or pay. Because remember, the judge only has the authority over the parties who have divorced. The husband and wife, or the parties, the judge has no ability to reach over and force your child to pay anything. There can be an expectation, and there should be a discussion and communication, as Gregg mentioned earlier, about who's going to be contributing, who's going to be paying, but a judge doesn't have the authority to force a child to pay. So if you agree with your ex-spouse that it's going to be 1/3, 1/3, and then come September and the tuition bill is due and your child refuses to pay his or her 1/3, there's nothing you can do about that. You can't sue your child under those circumstances and force him or her to pay. So you need to make sure that you've had a really heart-to-heart conversation with your son or daughter to make sure they understand what their financial responsibilities are for a very expensive college endeavor.
And I would just add, Francine, that in terms of the Mass State College cap that was asked about, the court uses the cost of UMass Amherst. And as Francine pointed out when she was speaking in her presentation, the court does have the ability to order someone to contribute more than 1/2 of the cost of UMass Amherst. However, they have to make very specific findings about a parent's ability to contribute more than that. So I had used the example, if your spouse wins the lottery and is now, sitting on millions and millions of dollars, then certainly that would probably be a circumstance where you could argue for a greater contribution than 50% of the cost of UMass.
And so then the second question, I think, is similar, where it says, can the child be required to participate financially through work study, part-time job, and summer job? Again, it's a conversation with your child to ensure that he or she understands the financial commitment to any institution, whether it is UMass Amherst at $33,000 a year, or I think Gregg said the most expensive school out there is over $80,000. So there needs to be communication, understanding, and agreement in your family that your child is going to work in the summertime, will maybe work during the school year and contribute his or her earnings towards his or her, educational experience.
Yeah,
Andrea,
I'll just
go ahead,
add
Greg.
there, because it does really, that upfront discussion and setting that expectation, because there's such a pull for young people. They don't quite understand the money part of it in many cases, right? They don't really appreciate having $10,000 worth of debt or $20,000 worth of debt per year, that's a meaningful difference when it is. So I think that really getting them to understand what their contribution is going to be, if they want to stretch in school that's more expensive, they have to understand the portion that's going to be on them. And that way they hopefully get it if it's beyond what they are comfortable doing, and that you're comfortable allowing them to do. Because, even though the student might say, oh, I'll just take out more debt, you still have that role as a parent to say, I don't want to, don't hurt yourself. And it could. And I've seen students push a parent, that to allowing them to make a bad financial decision for either the parents or themselves. So when there's been a divorce and maybe there's one parent that's trying to please the student more than the other, it can get a little bit good cop, bad cop kind of a situation that you've got to really be careful to navigate around with it. So upfront communication, I can't hit this hard enough, early on in the process, and letting out the ground rules allows you to prevent situations where a student's refusing to pay his portion or her portion. Ex-spouse.
So we have one more question in the Q&A. The question is, what if parties decide to change custody to the lower income parent in order for the child to qualify for more financial aid? Are the colleges aware of this happening? Greg, have you seen this?
Yeah, I have. And so, the rules are that the student, whoever the student lives with in the prior 12 months, greater than 50% of the time. Is it possible that a student, as they're going through the college years, change custodial parents? Absolutely. And it gets kind of gray too when the students live the majority of the year away from home. Who's the custodial parent? So I think it's worth it to really think about who is going to be the custodial parent and make sure that you've got that ground covered. That that is the person with if it's a toss up, it could go either way from a because of the relationships that exist. Then yes, it could behoove you to have them live the majority of the time with a lower income parent, and it could save a lot of money. The one thing I've seen for students that coming from high school, well, maybe they go to a town's high school, a public high school in town, and then the ex lives in a different state or a different city, and they try to claim that parent as the custodial, then that's a problem, right? Because their application is saying, I live in town A, and put your financial aid applications trying to justify that you're living in town B. So, but as they're going through the college years and you're reapplying for financial aid, yeah, if the living situation can be justified, then you can change the custodial parent.
And when you talk about majority of the time, it's really just a day beyond 50%, right? And that's considered.
Yep, it's 50%. And it gets really kind of, if it's 50-50, then it's supposed to be who provides more support. But that's even something that can be gray. So yeah, they just have to live an extra day at the parent that's got the weaker profile. And you can potentially get a lot more money if they're only looking at the custodial parent's finances in the financial aid assessment. And that's where there's a real variation. Before you start changing where your child's living, you can start to consider even what schools are they looking at if they're that far along in their search. And what's are they looking at both or looking at one? I've had families that have had their student really focus on only schools that don't look at the wealthy X, because they're, they would negate any chance for substantial need-based financial aid. So you can really think about those schools accordingly, and you like to see them all play out.
I was just going to say, I think maybe you can confirm that the more exclusive schools do look at both parents. So changing custody may not be the best option. Is that accurate?
That's right. I mean, generally speaking, the more selective privates are the ones that are going to look at both, and therefore it won't matter to change.
So I think we have come to the end of our webinar. I don't see any more open questions. Thank you so much, Greg, from Campus Bound, for joining us. I know that you joined us a few years ago and it was so informative, and thank you again for doing this webinar with us. And Andrea, always fun to do a webinar with you as well. And we have put up our information should you need to reach out to Greg and ask him about financial aid and applications. I know he'll be immensely helpful. He has been to a number of our clients in the past. And I'd ask that you reach out to Andrea and me if there's a need for a modification or a contempt, or you just have a question about child support and college costs. So thank you everyone for joining us.
Yes, thank you everyone.
Thank you.
Take care.